This is Bloomberg Law with June Grasso from Bloomberg Radio.
The prosecution's case against Donald Trump in the hush money trial is nearing an end. Its star witness, Michael Cohen, was back on the stand today as prosecutors continue to try to connect Trump to the hush money payment to adult film actress Stormy Daniels. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter English. Michael Cohen, the star witness by every account, do you think the prosecution could get a conviction without his testimony?
Michael Cohen is absolutely the key figure in this trial. He's the linchpin of this entire alleged crime because he was the person who carried out the alleged orders of former President Trump. He was the person who arranged for the payments, and he is the person who provides for the jurors the insider's view of the complete hatching of this alleged conspiracy. So he is the central figure, and ultimately the prosecution will either sink or swim based upon the credibility of his testimony.
He's also the only person whose testimony includes what Trump allegedly said and knew about the payment to porn actress Stormy Daniels. But he's such a flawed witness, such a problematic witness. You know, he's been convicted for lying to Congress, lying to banks. And in his testimony, he's had to say over and over again, that wasn't true. That wasn't true. So why would the jury believe him?
Well, there is no question that he's an enormously flawed witness from the standpoint of prosecutors. Typically, prosecutors do use cooperating witnesses who carry with them a certain amount of baggage. They're often people who have committed other crimes. They're often people who have lied before, who get caught in lies based upon tape recordings and other related information. But Michael Cohen does stand alone in the pantheon of cooperating witnesses in terms of the breadth and scope of the information and the evidence that defense lawyers will be able to level at him throughout his testimony, because he not only has obviously a vendetta against former President Trump, but he's been extremely vocal about it. He's also a convicted perjurer, and they will make great use of that, reminding the jurors over and over again that he was convicted for lying to Congress, lying to banks. He will say, and prosecutors will no doubt argue, that that was all done at the direction of Donald Trump, and Donald Trump was the one who selected him to carry out the type of work that he wanted. So he was, in many ways, the living embodiment of the Trump organization, or at least the part of the Trump organization that allegedly carried out these shady schemes. But still, the defense lawyers have a lot to work with here. There's proof of lying. There is a clear vendetta here. And there are examples after examples of how Michael Cohen has personally profited from this incident, making millions of dollars from books, from TikTok appearances, and apparently is now hawking a reality TV show. So that does give them the opportunity to argue to jurors that this is a person who will say or do anything to make money. And at this point, his way of making money is attacking former President Trump and linking him to these alleged crimes.
It seemed like there was a contradiction in what Cohen was saying. On one hand, that Trump was a just do it guy. You know, he would tell him, just get it done. But then on the other hand, that Trump looked at every penny that was going out of the company. Are those contradictory, or can they be reconciled?
I think they can be reconciled, but you're right that they are contradictory. I mean, it shows on a certain level former President Trump in the way he ran his organization. He did it on a high level. He gave orders. He told people what to do. He didn't get into the weeds as to how they should do it. But then there is also evidence that he did like to follow up and wanted to know a lot of the minutia, what was going on, how it was getting done, why it was getting done. And so it is a bit of a contradiction, but often people are contradictory in nature. And so I think there's sufficient evidence here to show that there were these two sides to the way the Trump organization was being run by former President Trump.
At the end of the direct examination, the last part of the direct was the prosecutor taking Cohen through, his various plea deals and convictions, etc., and allowing him at the end a mea culpa, saying that his moral compass was off. I mean, is that something that you expected the prosecution to do at the very end, or could they have sandwiched that somewhere else in the testimony?
Yeah, usually that type of testimony comes more at the beginning of a case. The basic rule for prosecutors is when you have a witness that has a lot of baggage, that has a lot of things that he or she may have done that you know the defense knows about, and they are going to bring it up with a ferocious attempt to discredit your witness, you front that evidence before they get a chance to raise it during cross-examination. So it's no surprise that they're going through all of these contradictions, the convictions for lying, all of the bad things that they think Michael Cohen has done. And not only did they do it through his own testimony, but here we saw prosecutors really beginning to attack their own witness through prior witnesses. They had Hope Hicks, for example, testifying about Michael Cohen, and other witnesses testifying about Michael Cohen in ways that were less than flattering. But it was, I think, a very shrewd move by prosecutors to try to begin very early on to paint Michael Cohen as a flawed character. They're trying to show jurors that they understand that Michael Cohen is not a paragon of virtue, that Michael Cohen has lied before, that Michael Cohen is an imperfect witness. But on the other hand, he is believable, according to prosecutors, because of the detailed information that he is giving jurors and the fact that a lot of the testimony that he has given is being corroborated by other witnesses and by documents.
When the cross started, there were more than 80 objections in less than half an hour by the prosecution, whereas the defense objected very little during the direct testimony. It started with a question where Todd Blanche asked Cohen about a Twitter post where Cohen called the defense lawyer a crying little blank. It was objected to, and then the judge struck it from the record. Is that a tough way to begin a cross?
Well, no, I think you do expect defense lawyers to come out of the gate very aggressively. And even in a circumstance where the question is stricken, they still make their point. The judge will instruct jurors not to consider the question or the answer, but they've heard it. And you will see defense lawyers come out very aggressively, even asking questions that they know are going to draw objections, and even asking questions that they know may draw objections that are going to be sustained by the court. But it's really setting the stage. It's showing jurors that defense lawyers do not believe this witness, that they are going to attack his testimony, that they are going to challenge his testimony at every turn. I think it just sets the stage for what we are going to see over the next several days as the Trump defense team goes at Michael Cohen and tries to pick apart his testimony and his credibility.
They also, and this is not hard to do, to show this litany of Cohen's attacks on Trump, attacks in books, in podcasts, in TikTok. I mean, it seems like it's easy for them to show that he's biased against Trump. How does that affect the jury?
Well, the ideal witness, from the prosecution standpoint, is a witness who has not made any statements about the case, who has never spoken about it publicly, who has never written about it, who basically has no prior record that defense lawyers can use to cross-examine the witness. This is the polar opposite of that, because Michael Cohen has spoken to anybody and everybody who would listen. He's written books. He's done podcasts. It is virtually impossible for prosecutors to blunt all of the statements that he has made and all of the instances in which he has shown a strong dislike for former President Trump and obviously a bias against him. So that's something that prosecutors just have to concede comes with Michael Cohen, and they just have to argue that despite the fact that he clearly has a bias and even perhaps a vendetta against him at this point, that he's still nonetheless telling the truth. And there is some testimony that prosecutors can point to show that for a very long time, Michael Cohen was incredibly loyal to former President Trump, and there are statements by former President Trump that were reciprocally loyal to Michael Cohen, saying that Michael Cohen was a good man and a good lawyer. So you can really see that this is a relationship that has changed dramatically over time due to circumstances.
I'm surprised the prosecution is ending its case with Cohen. I thought they would end with a less controversial witness or someone who would back him up with documents or something like that. What do you think about the way they're ending their case?
It is a little bit of a surprise. You typically want to save this star witness, the one who you know the defense is going to savage for days on cross-examination. You want that to be near the end of the case, but you usually do not want it to be the very last witness because you don't want the cross-examination to be the last thing that jurors remember about the witness. Now, prosecutors will get a chance to redirect, and then there will be recross, but at the end of the day, it's really the cross-examination that will stand out most in their minds. And so usually you then want to shift to a witness who is less controversial, who might be introducing some documents, something that is really unimpeachable so that you can put a witness on the stand who defense lawyers will not be able to really score any points with. And so you end the trial on a positive note with a witness whose testimony cannot really be challenged.
The trial may not end. And let's go back to the question that I've asked you so many times before. Could Trump, or might Trump, would it be wise for Trump to take the stand in his own defense?
Well, obviously, that's a decision that he and he alone will make. It's also a decision that he will make likely in consultation with his lawyers at the close of the prosecution's case, which is now coming up. So he'll have to face that decision. The defense team will begin to present their case when the prosecution ends. They can present other witnesses first if there are other defense witnesses. So there may be some more time before former President Trump has to ultimately make that decision about whether or not to testify in his own defense. But the general rule is no matter how effective a defendant may feel they are in telling their side of the story, it is usually better for defense lawyers to make their case through cross-examination because the burden of proof lies with the prosecution, and to the extent that the defense can pick apart prosecution witnesses and raise reasonable doubt in the mind of jurors, that's all they have to go for. Remember, at the end of the day, jurors do not have to find a defendant innocent. They simply find him not guilty, which means that the prosecution has not met that high level of burden of proof of proving beyond a reasonable doubt. So in some ways, when you put a defendant on the stand, that becomes a referendum on the credibility of the defendant. And that is a difficult battle to win. And it also suggests to jurors that in some way, the defense has to prove the innocence of their own client, which is not at all the standard. And it also gives prosecutors the chance to essentially retry their entire case through cross-examination. So in other words, if former President Trump were to take the stand, the defense would have an opportunity to question him on direct examination. But then when they were done, just like the defense had a chance to cross-examine the prosecution's witness, the prosecutors would spend an enormous amount of time cross-examining former President Trump, and they could literally ask him any question about anything he testified during his direct, which means they could probably retry the entire prosecution case by asking questions on cross of former President Trump. That usually does not end particularly well for defendants, so it's going to be very interesting to see what he does when the time comes to decide whether to take the stand in his own defense.
We'll see if Trump and the defense follow that rule. Thanks so much, Bob. That's Robert Mintz of McCarter English. Coming up, Republican states challenge new Title IX rules. This is Bloomberg. At least 22 Republican-led states are challenging the Biden administration's new Title IX rule that expands protections to LGBTQ students and adds new safeguards for victims of sexual assault. Under the new rule, Title IX, which forbids discrimination based on sex and education, will also protect against discrimination based on sexual orientation or gender identity. Joining me is Paul Smith, a professor at Georgetown Law. He's an expert in civil rights and civil liberties issues. He argued and won the landmark gay rights case, Lawrence versus Texas, at the Supreme Court. Pleasure to have you, Paul. Will you start by telling us about the Biden administration's expansion of Title IX?
Well, the action that was taken just recently to finalize new regulations to add additional rights under Title IX to LGBTQ students was in many ways a restoration of the rules that were in place under Obama and had been cut back during the Trump administration. The Biden administration is going even further, clarifying several things. The first thing it's clarifying is that discrimination against people based on sexual orientation and or transgender status is a form of sex discrimination violating Title IX. Title IX is a statute that forbids sex discrimination in educational institutions funded by the federal government. The second thing it does is it gives very specific examples of what constitutes discrimination against people based on sexual orientation or transgender status, gender identity. And so, for example, it makes it clear that schools have to allow transgender students to use the bathroom and changing facility consistent with their gender identity. They can't refuse to use their preferred pronouns and that sort of thing. And, discrimination against same-sex couples in terms of going to the prom or whatever is clearly illegal. And failure to protect students from harassment and bullying based on the fact that they're gay or lesbian or transgender is a violation as well. So that's all been clarified and set forth in terms that are easy to understand and are specific enough so that a lot of the fights we used to have about what is discrimination and what isn't will no longer be happening.
Now, is this because in the last few years, a lot of Republican-controlled states have adopted laws restricting the rights of transgender children? 10 states at least bar trans students and staffers from using bathrooms that correspond with their gender identities. And then there are restrictions on how LGBTQ issues are taught at school. Are these Biden administration updates designed specifically to counter those laws, or are they standing on their own?
They're part of a much broader and longer-term effort to establish federal protection for gay and trans people against discrimination. In this case, in the school environment, but we've already seen a successful effort to establish that it's illegal under federal law to discriminate in employment. That was a Supreme Court case decided 4 years ago that interpreted not Title IX, but Title VII, which covers employment. It said discrimination against people based on transgender status or sexual orientation in the workplace is sex discrimination and therefore illegal. And so, this fight's been going on a long time. I had a case nearly 10 years ago in North Carolina about their bathroom bill that was trying to keep transgender students out of the bathroom of their gender identity. And we were arguing about Title IX and the 14th Amendment. And so, while clearly this, I think it's been perceived by the red state attorneys general as a kind of a pushback against some of their laws, and it does have some of that effect, it is part of a broader battle to establish basic protections for transgender and lesbian and gay and bisexual students in federally funded educational institutions. And that, in turn, is part of a broader effort to establish protection in all kinds of places for people who are experiencing discrimination.
I believe there are 4 lawsuits by attorneys general in more than 20 Republican-controlled states, so Republican attorneys general. Are those lawsuits on the same grounds?
I haven't studied the complaints, but it's pretty easy to figure out what they're arguing. Basically, they're going to go into court and say these regulations requiring people to have access to the appropriate bathroom or changing area or pronouns or whatever are not properly based in the statute, that the statute doesn't provide a legal basis for protecting people from transgender discrimination and sexual orientation discrimination. It's about sex discrimination in the more conventional sense. And so it's a basic administrative agency challenge to the regulations that's going beyond the statute. I don't know where they filed these things, but I assume they found courts with nice conservative district court judges who may very well agree with them, at least initially.
Yes, they did. They found one of them's in Texas.
Oh, it's almost always the one up in Amarillo, Texas, yeah.
Right. From Texas to the Fifth Circuit to the Supreme Court, perhaps. I mean, you referred to the Bostock case. And that was close. That was 5-4, right?
Right.
So do you think that if this goes up to the Supreme Court, that they'll affirm their changes, or do you think that they'll go along with the Republican attorneys general, or too soon to tell?
It's probably too soon to tell, and it's probably not a yes or no answer, because a lot of what may happen in these cases may be sort of careful parsing of what some of these rules do. One of the things we've seen in this Title IX area is people wielding Title IX on both sides. And so if you're against having transgender girls go into the girls' room in the junior high school, one of the things you might argue is that it's discriminatory against the rights of the other girls. And that's an argument that's been made. And the same might be true about locker rooms or whatever. And certainly in the area not covered by these regs, the area of transgender athletics, That's another area where Title IX gets wielded on both sides of the V. And so one of the things that might happen in a pretty conservative Supreme Court is they might say, well, we don't dispute the idea that discrimination based on sexual orientation or transgender status can violate Title IX. But what is discrimination? Is it if the school says we're going to decide who goes to which bathroom based on physical characteristics or gender assigned at birth or whatever, and they do that, is that discrimination against somebody? Those are issues that have been fought out over and over again, and reasonable minds kind of disagree about them.
You mentioned transgender athletes, and the new rules don't address transgender athletes. And I've read that...
Not yet, anyway.
Well, I've read that they might be avoiding that because of the election coming up and how that's such a hot-button issue, even more so than transgender rights as far as bathrooms, et cetera.
Yeah, it's by far the biggest one. I think they got 150,000 comments about the proposed regulation that was put out 2 years ago as part of this package to establish the principle that transgender athletes need access to the teams just like everyone else on an equal basis. And, it would be pure speculation on my part whether they just found this issue harder and therefore they're taking a longer time to finalize, or whether they've decided this might be better promulgated in December of 2024 rather than before the election. It's hard to say.
So now in some Republican-led states, governors and education secretaries are discouraging state officials from complying with the new federal regulation. So let's go to Texas, which is always on the outer rim. The governor, Greg Abbott, sent a letter to Texas's public university systems and community colleges instructing them to disregard the new provisions. Texas will not comply with President Joe Biden's rewrite of Title IX. I mean, what effect does it have on funding for the schools if the schools don't comply?
Well, in theory, that could lead to a cutoff of funding, although it's a rare situation in which schools actually lose their funding. But what will really happen here is, while the governor has made this dramatic statement of civil disobedience, effectively, is that they'll be in court within a few days, and somebody will decide whether these new regulations will be put on ice pending the further litigation of the case or not. And if they are, then they won't have to comply with them. There'll be a preliminary ruling that stays their effect. If they're not, and the judges say, we think the regulations can take effect now while you litigate up through the courts, then that becomes a more serious matter. But I wouldn't be at all surprised, given who got to decide where these cases were going to be filed, that they'll find judges who will say, let's just enter a preliminary order stopping these regs from being in effect as we go up through the courts.
Another thing that these rules change is the rules that the Trump administration put into place about hearings on sexual harassment, et cetera, on campus, where under the Trump administration, the accused had a right to cross-examine the accuser.
It's very clear that there was a perception that the pre-Trump rules under the Obama administration were too favorable to the accuser, that Betsy DeVos tried to come up with a new system that gave greater rights and protections to the accused in these cases involving, primarily this involves student-on-student sexual violence, date violence, that kind of thing. And this does seem to be designed to restore what is viewed by the Biden people as a more fair balance of rights on both sides of the controversy in those difficult cases.
It's obvious that as administrations change, these rules change back and forth. I mean, it seems like not the best way to be establishing, rules for schools when it changes from administration to administration.
Yes, it does show you how political a lot of this stuff is. And, until this gets settled, you're going to see some of this. But what usually happens in this kind of situation is that after a period of tit for tat, back and forth, eventually things kind of calm down and people get used to a rule and it stays in place.
So you've been litigating in this area of LGBTQ rights. Are you surprised that it seems as if in some respects we're going backwards?
There clearly is a political effort to push back on some of the progress that the LGBTQ movement for equality seem to be making, looking for vulnerabilities. And the main vulnerability that they have found, the forces opposed to equality, is transgender students. That's a newer group that has less sort of comfort level among the general population. And so they've looked for ways to kind of turn the non-transgender students into victims, asserting privacy in the bathroom or in the locker room, claiming that teachers have a religious right not to accept a new pronoun or a new name, that kind of thing. And so while, certainly there's still plenty of discrimination against same-sex couples and gay and lesbian people in the school systems, the transgender students are a particular focus on a real political hot-button issue right now.
And outside the legal questions, I just think it's very sad that a vulnerable population has to go through this.
Transgender people, non-binary people, they have very high levels of difficulty accepting themselves. The suicide rate's very high. And instead of just trying to make it as easy as possible for them to get through their childhoods and get up to wherever they're going to end up in life, people are actually making it harder on purpose. It really is sad.
It's been wonderful having you on, Paul. I really appreciate your insights. That's Paul Smith, a professor at Georgetown Law. Coming up next, are video games addictive, causing health issues like ADHD and depression? Can children playing video games too much over years lead to brain damage, stroke, or multiple psychiatric disorders? Those are some of the claims in a wave of lawsuits that accuse the video game industry of profiting from intentionally promoting mass addictions. Parents' attorneys are attempting to have more than a dozen video game addiction lawsuits filed so far, grouped together before a single federal judge in Salt Lake City. Joining me is Bloomberg legal reporter Rachel Graf, who's written about these video game addiction lawsuits. These parents are saying that the games are not only addictive, but they're actually causing physical and mental problems for their kids?
Yes, so they're claiming that the games have affected their children's brains and contributed or caused physical issues such as seizures, attention deficit disorder, social isolation, and so on.
I mean, is there scientific proof to back that up?
The complaints do cite medical studies that do appear to back that up to an extent. The World Health Organization actually recognizes, I believe they call it internet gaming disorder, as a diagnosable illness, but other medical institutions are still studying whether they're going to follow suit.
And tell us about the plaintiff's claim about the algorithm functioning like a casino slot machine.
Sure. So these gaming lawsuits and then thousands of other lawsuits have also been filed against social media companies for being allegedly addictive, and there was even one lawsuit filed against dating apps for allegedly being addictive. And what all of these lawsuits have in common is that they're claiming that the technologies function similar to winning a jackpot at a casino. And basically, some of the lawsuits cite B.F. Skinner's, the psychologist's experiments with lab mice, where he found that if the mice pulled a lever, if they got treats randomly, they were more likely to keep pressing it than if they got the treat, consistently and predictably. And so the complaints are saying the same thing is happening here, that these children are getting random rewards, be it in the form of actual time release rewards in the video games or likes on social media or matches on the dating app.
And how have the video game companies been responding?
So one of the hurdles that the litigation faces is actually proving that these video games directly caused some of the harms alleged and that the children aren't just experiencing some of these illnesses and other effects as a result of their day-to-day lives. So that's one issue. And then the gaming companies have also said that millions of people play these games every day and they don't have these problems.
Yeah, I mean, that seems to be a big issue. Do you know how many lawsuits there are already and how many kids are alleged to have been affected this way?
It's nowhere near as many as the social media litigation, which, again, I believe is now over 1,000 lawsuits. I mean, there's at least a dozen of these types of lawsuits that were filed against the gaming companies, but they're are more filed quite frequently. And so I expect they will continue to be filed.
Before we go on, explain what the social media lawsuits are about.
So those lawsuits, they have been consolidated in California in state court, and then others have been consolidated in federal court. And there are, like I said, many hundreds, if not over 1,000, I believe, filed by state attorneys general and school districts and parents of children claiming that the social media companies, including Facebook, Instagram, Snapchat, TikTok, that they've intentionally designed their products to addict young people and have contributed to this mental health crisis among children.
And none of those lawsuits have gone to trial yet, right?
Right. We're still a ways off from that. The social media lawsuits, the judges in the state court and the federal court issued somewhat positive rulings. They allowed some claims to move forward, and so the people who brought those complaints, I think, are viewing those as a win, as are the parents of the video game lawsuits. Let's
talk about some of the challenges that you mentioned in your story. Explain Section 230 and whether that will be a problem for them.
So Section 230 is a law that technology companies have relied on for a long time to say that they're not responsible for any third-party content on their sites. And so the social media companies tried to use that law, but the judges actually weren't persuaded by that argument, in part because they're developing the algorithms that push the third-party content onto the children, and so it's not like they're completely hands-off. They are having a role in what these children see. The video game lawsuits haven't reached that stage yet. Some of the lawyers that I spoke with for this article mentioned to me that some of the video game companies might have a stronger defense than others. Roblox, for instance, as I understand it, they don't develop their own games, and so they might have a stronger Section 230 defense because, again, it is more so third-party content that maybe other developers who do create their own games will have.
Another hurdle might be the First Amendment, that they say the content is protected by the First Amendment.
That's right, yes. The video game publishers have compared it to suing a video game library for distributing supposedly addictive movies. And so they're saying that, you wouldn't sue over that, so you can't sue us for this, and it's protected under the First Amendment.
You mentioned that the laws governing personal injury, how they play in here.
Many of the lawsuits bring product liability claims, which are typically brought against physical products for being faulty. These technologies aren't really physical products that you can necessarily hold. They're more so, algorithms, and the defendants in these lawsuits have referred to them as platforms or services to try to make that distinction. And so that'll be another source of debate among the parties, is whether you can actually bring product liability claims against these technologies.
I don't know if they've gotten to this point yet, but perhaps they have in the social media cases. How do they handle the fact that the parental responsibility to supervise your kids and keep them off games or apps that seem to be harmful to them? Because that's what came to my mind first. Well, the parents have to supervise, don't they?
You would think so, yes. And actually all of these lawsuits, I believe, were actually filed by the parents claiming that they have been harmed as well. They're saying that their children, if they try to prevent them from playing video games, that they actually experience withdrawal symptoms similar to those that you would experience when trying to stop like a nicotine addiction or something like that.
Tell us about the comparison of these addiction lawsuits to the addiction lawsuits against the big tobacco companies.
So those lawsuits, they also, the tobacco lawsuits, they also brought product liability claims, and so I think there are some similarities. But the tobacco lawsuits, they took a long time to reach a resolution. They eventually did. The plaintiffs in those cases eventually did achieve major settlements, but I believe it took decades, and so I think we're definitely still at the early innings with this batch of lawsuits against the technology companies.
And they're trying to get these supervised by one judge in a multi-district litigation?
So that has already happened with the social media companies, and so all of the hundreds of lawsuits have been consolidated in California under either one federal judge or one state judge, depending on the specific claims. And so there are hundreds of individual lawsuits, but for efficiency's sake, one judge is making rulings that apply to all of those lawsuits. And the video game lawsuits, they haven't been consolidated yet, but there is a hearing later this month to try to get them consolidated under one federal judge. They're not class actions because they're alleging different harms based on the individual child, but for efficiency's sake, they are trying to get them before one single judge.
These kind of things, you look at it and you think, well, maybe the video game companies would want to settle this and get it out of the headlines. But this may be a case that they want to fight because, A, they'll be open to so many claims like this, but B, it sounds like they have some good defenses.
I think so, and I don't think anyone really wants to prognosticate too much, but I think it's definitely not a shoo-in for the plaintiffs, and different video game publishers might have different results, but it does seem like they're certainly not settling yet.
And I have to ask you about the dating app lawsuit. It seems to me like almost bordering on ridiculous claims that dating apps are addictive.
Sure, yes. So the video games and the social media, they were filed on behalf of children. And the dating app, there's one lawsuit, and it's filed on behalf of adults who use dating apps, claiming that the apps are addictive as well. But, the harms there are allegedly like $100 that these adults paid in subscription fees versus, these children who in some of the social media cases have maybe committed suicide or they're, suffering from these serious illnesses. And so it's not a one-to-one comparison.
No, it's not. It sounds very different. Interesting story. Thank you so much for being on the show, Rachel. That's Bloomberg legal reporter Rachel Graf. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.